Testing, testing. Okay, welcome to the Public Service Commission's administrative meeting for May 7, 2025. First item is our approval of our minutes from the meeting of April 30, 2025. Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Oh, I think I'll have to abstain on that one. I was watching the waves at the time of the meeting.
Fair enough.
Not to rub it in or anything.
Commissioner Richard.
Aye.
I vote aye.
Good morning, Mr. Chair. There are 6 items on today's consent agenda. However, we will be taking item number 1 after the other consent items, so taking it off the consent agenda. Item number 2 is an application for operating authority from PB Maryland Asset Entity, LLC. Item number 3 is a notification of new financing arrangements from GC Pivotal, LLC. Item number 4 is an application for a license to supply electricity from Harbor Light Energy, LLC. Item number 5 is an application to supply natural gas from the same company. Item number 6 is a notice of participation in financing arrangements from a variety of telecommunications entities.
Okay, regarding item 2, I move we grant the requested operating authority and grant the requested COMAR waivers. Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye. Item 3, I move we note the company's new financing arrangements. Commissioner Linton.
Aye.
Commissioner Barve.
Aye.
Commissioner Suchman.
Aye.
Commissioner Richard.
Well, that's
Aye.
because he went on vacation and I sort of bumped him
Commissioner
in
Richard.
seniority.
Aye.
I vote aye. Regarding item 4, I move we grant the company a license to operate as an electricity supplier in Maryland, limited broker services for the customer classes and service territories applied for and recommended by staff, and direct the company to notify the commission within 30 days of any changes in the information contained in the application. Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye. Regarding item 5, I move we grant the company a license to operate as a natural gas supplier in Maryland, limited to broker services for the customer classes and service territories applied for and recommended by staff, and direct the company to notify the commission within 30 days of any changes in the information contained in the application. Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye. And regarding item 6, I move we note the notification of the financing arrangements. Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye.
And the remaining item is a notice from Traverse Casualty and Surety Co. of a bond cancellation for Charity and Power, Inc.
Good morning, Chair and Commissioners. Charles Herbert on behalf of staff. Item number 1 on today's consent agenda is a notice of bond cancellation from Travelers Casualty and Surety Company for Charity Plus Power, Inc.'s surety bond for its electricity broker license. Regarding Charity Plus Power's bond cancellation notice, staff attempted to contact the company by email on March 20th, 2025 regarding the notice of its bond being canceled. However, staff received no response to that email. Staff later called the company and learned that the company did not wish to remain licensed. Staff informed the company of the standard procedure to request cancellation of their license. However, despite repeated reminders, the company did not file a license cancellation request, nor did it take actions to maintain its bond. As failure to maintain financial integrity would put the company out of compliance with COMAR 20-51-02-02C, staff is recommending that the Commission revoke the company's license for failure to maintain its bond. Staff does note that the company owes $100 in outstanding assessments for its failure to maintain its 2023 gross, or failing to submit its 2023 gross operating revenues form to the Commission. So that's a penalty that the fiscal division assesses whenever a supplier does not timely submit their GOR form. Charity Power Plus Power has no outstanding renewable portfolio standard obligations, nor does it have any complaints, nor does it have any active customers in the state. Finally, the company is not currently in good standing with the state Department of Assessments and Taxation. With that, staff is available for any questions that the commission may have.
Any questions? So, I guess the upshot is they owe us $100.
They do owe $100, yes. The bond remains in effect until the end of the business day today. That's how these surety companies typically handle it. But today's date is the date that the bond would ultimately cancel. So it presumably, at least until the end of the day, the bond is available.
And you said they're not in compliance with the Department of Assessment.
They're not in good standing.
Right.
So they have not. This happens when a company has not filed their annual report with SDAT, and so they haven't done that in a timely manner. They're put in a status of not in good standing. If they are not in good standing for an extended amount of time, it becomes forfeit.
Okay. But I guess my next question is, so how do we get our $100 that they owe us?
There are a few options available to the commission. Typically, what staff sees is that these are sent to collections. When the bond is, so long as a bond is maintained, it's possible for the commission to file a claim. Whether that claim goes through all the steps and ultimately makes it back to the commission isn't, to my knowledge, a guarantee. I've only seen a bond called once in all the matters that I've handled, and that was for a civil penalty close to $7,000.
So, well, actually, so Commissioner Sussman, and then I'll come back to you.
So I'm trying to sort of figure out what our recourse is to the extent that there is, so that we determine that there is some liability that would inure to them. If we cancel the license, we can't reach them. I'm assuming they're done. They're beyond our jurisdiction. So in order to be able to reach them for whatever reason, we'd have to keep the license in good standing, correct? Mr. Albert.
Good morning, Commissioners. Kenneth Albert on behalf of staff. This brings to mind the Agway proceeding that I think the Commission is reviewing right now at the April 24th administrative meeting. This very issue came up. Whether because of concerns that licenses, authorization for a supplier is terminated on day 1, and on day 10, a customer who, when they were an authorized supplier, submits a claim, well, the bond is gone. And the commissioners addressed the issue of whether we should require a supplier to retain a bond after it's been terminated, its authorization has been terminated. So that would be one option. Now, again, here, the problem we have here, and we appreciate, and LPC will be presenting, we appreciate their concerns. How do we ensure that we can reach this company? Is there is no bond that.
Well, it's not just how, I mean, they clearly have not been very responsive to your outreach. So how would staff require and be able to require them to successfully secure a bond? But the reality is you wouldn't even be able to do that if we revoke their license. So at a minimum, I mean, it seems to me that we shouldn't be revoking licenses if there's any way that we feel like we need to be able to reach them.
Right. I mean, again, as I understand, the commissioners going to address that issue. Can you require a supplier to maintain a bond even though their authorization has been terminated?
Okay,
And
so-
we have
so-
no, I'm sorry.
Right, so if that issue is before us now, then maybe it's premature to be making a determination on this one as well.
Well, the only problem we have here is there is no bond to retain. These guys, and this entity has been totally unresponsive.
Right.
And with the Agway case, you had that option. There was a bond in place. You could require them to maintain it. They don't have the bond at all. As Mr. Herbert indicated, at the end of the day, technically, it'll be expired. So we can't use that as a hook. So there's like no real. We appreciate where OPC is going with this, but we just don't see a viable way of keeping them liable to us. You know, drawing on the bond, as you know, the commission just did that with respect to Smart Energy to recover a $250,000 civil penalty. So, I mean, the bond's used, but as Mr. Herbert said, we typically don't on $100 penalties. We don't typically rely on the bond.
Right,
That's not
I'm
the
less
big issue.
concerned about the $100 penalty than to the extent that there's a problem that comes up, you know, after the fact.
Yeah.
So are you asking, what is it that you're asking us to do? You're just noticing the cancellation, or are you asking us to take action? You're asking us to cancel the license?
Yes.
Okay.
Okay, yeah, it is specifically to revoke their authorization.
Okay, so if we don't revoke the authorization, then it at least leaves open the possibility that we could reach them if we need to to the extent, if we revoke the authorization, we're done. We can't ever go back. No one can go to them because we don't have jurisdiction.
And again, that begs the question, yes, and especially because you don't have the option of requiring them to maintain their bond post-termination, which is the situation you have in Agway.
In essence, yes, the commission would maintain its jurisdiction over this supplier. However, you would have a supplier that has no financial integrity standing.
Right, but if we revoke their license, then there's no way we could go after them. I mean, there may be a situation where it does present itself as a possibility that we could go after them, but certainly by revoking their license, we can't do that. But I'm assuming you also don't want them to be engaging in as a broker. They couldn't do that without a bond anyway.
Right, right. And then that's the situation. We can't allow them to continue operating just so we have continued jurisdiction to that extent. But again, it begs the question with Agway, and again, with the Agway situation is distinguishable because there is no bond to hold on to.
Mm.
So there's just no happy solution to OPC's very legitimate concerns from staff's perspective.
Okay, thank you.
Mr. Richard.
I was just wanted to understand how this bond works because it does expire today. If we were to call travelers right after this meeting and say, hey, we'd like we have a claim against the bond, I mean, is that something we could do? And does that then, I guess, delay the cancellation of the bond pending the, whatever administrative actions need to take place while they process a claim?
My understanding of how the bond works, as Mr. Herbert said, it is, as of this moment, the bond is in place. And I assume, presumably through the end of the day, business day, it is. So we could make a claim today and at the same time authorize revoking their license. The bond, again, is as of this moment, we could draw on the bond. That is available.
Well, I'm also, this was put in place per our regulation. I mean, is it always just within the purview, the authority of the company to cancel a bond at any time?
Well, the protection we have is the bond issuing company. Typically, how this arises is the company that issues the bond is required to notify the commission, I think, 60 days advance notice. So that's how we find out about these things. We rarely hear it from the supplier.
And to add on to Mr. Albert's points, The surety company has the express power to cancel a supplier's bond. Often that is because a premium was not paid or something to that effect. And that's when the window starts. They send us, the surety company sends the commission a notice that the bond is going to be canceled within 60 days. And then from that point, staff starts our process to see if the supplier can get back into good standing with the surety company and maintain its bond. This is an instance of a company that did not do that. And in those instances, so that
Okay.
we could have.
And I guess I was wanting to understand if we went ahead and exercised, our right to go ahead and try to draw on the bond for the outstanding fine, would that also, again, prompt the company that maybe they need to be a little more responsive, and that the possibility of their bond, not being revoked, could be in jeopardy?
What I can say, Commissioner, is when I had talked to this company, what they had said over the phone was that they did not want to do this anymore because they were losing too much money. This is, to my understanding, a one-person shop as far as this particular broker, and they just want to be done with the retail supply market.
Okay, I just was trying to look at how we protect the integrity of our process. We just, let anyone, fly-by-night companies come in and just sort of thumb their nose at our regulations. It does seem that, if we have till the end of the day this bond, why don't we exercise it, try to get the money they owe, and maybe there's an opportunity to have some kind of fruitful engagement, because right now they are just, again, thumbing their nose at us. So.
Yeah, we appreciate that. The concern, OPC's concern, would not be addressed, because that, we don't know what those potential liabilities, that customer shows up a week from now and says, oh, by the way, we had a contract with them that goes back 6 months.
I thought it might be a good step, actually, as we try to address some of OPC's concern, to try to at least hold on to the bond, while we still have it before, it ends the end of the day. So it also would be good maybe in the future. I mean, we got this on March 3rd. If we could, try to do something a little earlier than the day of a bond. But in any case, I'll stop there. Thank you, Mr. Chairman.
Commissioner Barbe.
Do we know when the last customer it was that this company served? How long ago? Do we know?
We don't know that at this time, Commissioner.
But we do. But there are no outstanding consumer complaints.
No complaints, and that's consistent with what we typically see from brokers, as opposed to full suppliers.
And I'm not remembering clearly from the document from Travelers, but did they state a reason for why they were terminating the bond? Was it just because there were no customers, or what? Do we know what their, was it lack of payment? Oh, well, what do you know?
They elected to.
No, they didn't give a reason. Okay. All right, I think that's it for me so far. Thank you, Mr. Chairman.
Commissioner Linton. Linton, do you have any questions?
Yeah, just good morning. Just one for staff. So the bond is not a savings account. We can't just go and get money out of it if we think there's something wrong. Is there a process we have to follow, or some steps we have to take? Because the bond expires today. So is there something that we need to do in advance or beforehand, or can we just call Travelers and say, hey, hold on to that bond?
There is a multi-step process that's involved. Perhaps counsel can speak more directly to the to how that process works. But yeah, you'd be correct in saying it's not a savings account that you could just pull.
Interesting question. I mean, can we tell the bond company that they've got a customer who has not paid the premium on the bond, and as per the terms of the bond expires at the end of this day? Can we tell them they have to retain the bond? And I'm not sure if we can do that, because at this point, the bond would be, the bond company would be on the hook for the liability associated with bond without getting paid any premiums to do that. I'm not sure I've seen that situation addressed, but I certainly see that as one tricky issue we'd have to confront.
With respect to actually drawing on the bond, that's not actually something that staff does. It's through the Executive Secretary's office and the Office of General Counsel. They generally actually carry out that process if the commission has a desire to do it. It's happened a few times, but not something that's frequent.
So there's an administrative process that the commission has to go through before we can go to the surety company and say, we need to draw off the bond.
The wording of the bond is usually that the commission has to make a finding that the company is insolvent and or unable to meet its obligations in Maryland, which I think you could safely do here since they've basically closed up shop. Once you've done that, then the commission would have to inform surety that you've done so and that you have a claim against the bond. I'm not sure whether the notice has to be in writing or not. Again, as I said, it's not a procedure that staff generally carries out, but I think essentially you have to give them notice that you intend to draw on the bond, and therefore they cannot simply cancel it until the claim is addressed.
Okay, and just to reiterate again, I know staff has already said this a couple times, but just to make clear, the commission and the staff has attempted to contact the company on several occasions, and they've not been responsive.
That is correct, Commissioner, in that they have not been responsive to our requests. They didn't respond to the initial email that we sent in March. During the phone call, we gave them the process that they would need to do if they wanted to actually request cancellation of their license, instead of facing the possibility of the license being revoked for failure to comply with license requirements. We had even gotten to the point to where we'd sent them everything they needed to be able to possibly make a filing. However, they never actually filed any sort of cancellation request. So.
Okay, and you've been saying they, and I don't mean to put you on the spot or anything, but is this a representative of the company that you've been interacting with?
This is the founder of Charity Plus Power.
Okay, so it's the person that originally got the license from the commission.
Yes.
Okay. All right, thank you. That's all I had. Thank you, Mr. Chairman.
Okay,
Very quick little question from a
Oh,
non-attorney
okay, all right.
point of view.
No, no,
Pardon me, Bonnie.
Sure.
So, speaking on behalf of the non-attorneys here, it says this cancellation is to take effect on 5/7/2025. Does that mean basically it happened at midnight yesterday and it's in effect right now and not going to go into effect at the close of business or midnight today? It's just an inquiring public would like to know.
So these are typically on not the day before, but 11:59 p.m. on the day that it actually cancels.
I mean, the way I read it is that it'll go into effect basically today, which means it really canceled midnight last night. Okay, whatever.
Okay, so on behalf of the lawyer side of the dais, you received a notice from Travelers Casualty that the bond was canceling. You didn't get the notice from Charity and Power.
Yes, these notices come directly from the surety company.
Okay, so separate and apart from Charity, let's just say you get a notice of cancellation of a bond from any entity that has a license to operate in Maryland, either as a retail electric supplier or broker. Is there any way in which you can prevent the bond from canceling? Because again, we're going to be in situations where entities are operating in Maryland, they're not operating with a bond, or they've decided to get out of the business. How do we ensure that those bonds stay in effect. I mean, these are, some of these companies are companies that are just going to disappear and won't listen to orders from us that they need to maintain the bond. How do we prevent the bonds from going away?
So, Commissioner,
You understand what I'm asking.
I believe I do. You're asking how we can prevent these bonds from.
Well, we've been talking about, I mean, because of SB1, we've got a whole series of companies that are no longer going to engage in retail electric supply. We've told them that they need to maintain the bond for 3 years, just in case something sort of comes up. How do you ensure that those bonds stay in effect? I mean, what's to stop these companies from just, they're not paying their premiums and they disappear and the bonds go away, and then we have a residential customer that has a legitimate complaint and nowhere to go. How do we ensure that those bonds stay in effect?
You can't.
We can't.
So what?
Oh, Mr. Spivak, I didn't want you to say that.
That's really what it comes down to. The only way you can ensure the bond remains in effect is if there is a claim against the bond. You have to go.
But a claim against the bond for when the bond was in effect. But once the bond, once you get a notice from Travelers or some other entity that the client was no longer paying the premium and the bond is no longer in effect, how are we gonna? We're sort of looking at this situation where we're going to try to keep the bond in place for 3 years. It sounds like we don't have the ability to make.
You do not have that authority. I mean, what it comes down to is that, the commission doesn't have direct authority over the surety. The
Well,
surety has not
But can that be a condition of engaging in retail electric supply in Maryland? Is that you have to assure us that the bond will be in effect 3 years from? I mean, these bonds are for how long? They're for a year. They're for 6 months.
They're normally for a term of a year.
Okay.
And they renew, essentially automatically.
Okay, so that's going to present a problem for us.
noted.
So are there 3-year bonds?
I have not seen one. I don't know enough about the surety industry to be able to say that there is such a thing. It's quite likely or possible, but
And expensive.
that would be my guess as well. Again, I mean, when we get that notice from the surety, if we have at that point some kind of claim against the company or the bond, then it's incumbent upon the commission to notify the surety of that claim and start the process of drawing against the bond. And at that point, you put a hold on the cancellation of the bond, essentially.
Right.
But
See, but I'm starting to think that we're sort of coming up with this new process where we're requiring that companies getting out of the retail electric supply business are still going to have to maintain a bond, and we won't have the ability to prevent them from skipping town and not maintaining the bond.
there is that. I will note, it's not entirely true that the commission loses complete jurisdiction over them, just in the sense that if you look at the penalty provisions of the Public Utilities article, it's not purely jurisdictional. It's not purely.
Yeah, but if we
directed
can't find
against
them,
jurisdiction.
then effectively we've lost the ability to reach them.
That is true, Commissioner. If you cannot find them, you cannot, you cannot push a claim or penalty against them. But, assuming they exist in the world and you can find them, Commission does have jurisdiction to impose a penalty on any person that violates the Public Utility article
Okay.
or Commission order or regulation.
Thank you.
Okay.
Good morning, Mr. Chair and Commissioners. Milan Tekle-Mikhail on behalf of the Maryland Office of People's Counsel. I will try not to reiterate the same facts that have been already discussed. OPC is opposing staff's recommendation to cancel Charity Plus Power Inc.'s electric supplier license or broker license, but instead we are recommending that they be required to either file a replacement bond or formally file a request with the commission to cancel their broker license after they have met all of their outstanding obligations. Now, Charity has been licensed in Maryland since November of 2018, so that is about 7 years of operation in Maryland. We have reached out to the founder, Mr. Kevin McSpadden, seeking information as far as how they were operating in Maryland, if they have served residential customers, when was the last time you've provided service to residential or other customer classes, and we have been unsuccessful in getting a response. Like staff has mentioned, Charity has communicated to staff its desire to relinquish its license, but has yet to file a proper request, and we are recommending that pursuant to the Commission's licensing authority and ability to adopt requirements it finds to be in the public interest, that the Commission require Charity to demonstrate that it does not have any possible outstanding liabilities and obligations to the state of Maryland or former Maryland residential customers prior to canceling the company's license. Now, it is in the public interest for the Commission to require such showing by Charity because before the company leaves the state's regulatory reach, like Commissioners Suchman and Richard have pointed out. Charity should be required to satisfy its outstanding assessment. It's not really about the amount of the assessment, but it is about the precedent that is set for other suppliers too. And so the fact that there is an assessment in place should be enough of an indicator for the company to satisfy before it is allowed to leave the state's regulatory reach. Moreover, it should also remedy any obligations it has with SDOT that is causing it to be out of compliance with the agency's requirements, as evidenced by its not in good standing status, and provide information to the Commission as to whether it has provided services to residential customers in Maryland within the past 3 years. Allowing the cancellation of a company's license because the company has been unresponsive and unwilling to go through the proper license relinquishment process sets a bad precedent to follow for other similar suppliers or brokers who are seeking to leave the Maryland market, but wish to avoid the Commission's scrutiny. And because of the implementation of SB1, the Commission has been in a trajectory of changing how it is evaluating license relinquishment requests, and this would kind of be in a phase 2 that effort, as it could be seen as a loophole by other suppliers that if they just ignore the request by staff or Commission and just cease to respond, that they could somehow circumvent the requirements that the Commission has been putting in place for license relinquishments. Once Charity has satisfied its obligations, it should file a written notice with the Commission requesting cancellation of its licenses, like other suppliers are required to do. If Charity instead seeks to maintain its license or fails to request its cancellation, the company should be required to file a replacement bond. Thank you, and I am here and available for any questions.
So actually, this is a question for either side, if you know. Where is this company located?
They are in California.
They're in California, okay. Do they operate anywhere else that you're aware of?
I do not know where else they operate other than Maryland at this time.
Okay. And apparently, between the two of you, it's been difficult to get a hold of these people, right? Or this person.
Yeah, it has been difficult to get a hold of this company. They haven't responded to any emails, and the only thing they have responded to is phone call and our contact information that we have, which, to my understanding, is the cell phone number of the founder and CEO.
Okay. So any questions for Commissioner Richard?
I guess for either party here. So since the company is the principal in this arrangement, they ultimately are going to have to make whole the surety company. Am I understanding how this works correctly?
They're the ones who have to maintain compliance and work that out with the surety company.
Okay, but it's my understanding that the surety company is there to make good on any claim. But are there any other potential, I guess, claims or penalties that the company is at risk of right now under this current circumstances? You say there's $100. You mentioned that there's another state agency that might have a claim. Is that correct? I guess what I'm trying to get to is just, is there an opportunity here to really kind of get the company's attention so that I think a good point was made that all companies see that, just ignoring the commission is not going to be acceptable. That as long as we have this $10,000 or whatever the bond amount is, there's a potential that that principal, in this case the company, is going to have to, now make good with the surety company, because I'm sure they also have mechanisms that could make it very uncomfortable for the principal if they don't pay.
As far as staff is aware, the $100 penalty for not submitting the 2023 GOR form to the Commission's fiscal division is the only penalty that we found, and that $100 is the only financial outstanding obligation that they have.
So that would be our only claim that we have right now against the company.
Yeah, and one concern is there, and again, OPC's very legitimate concern that there may be these actual consumer issues, customer problems that will come to light a week or 10 days from now. But as my understanding, as far as drawing on the bond, that is until assuming it's still in effect as of this very moment. My understanding would have to be for a discrete claim, and the $100 penalty imposed by this commission for failing the company's failure to file their gross revenue report. I don't think we could, we'll have to look at this, but my understanding is we could not just draw on the bond today and just cite potential liabilities that the commission might impose in the future based on bad acts by this company in the past.
Okay.
That would not be a discrete, my understanding, the commission draws on the bond with a very discrete claim.
Okay.
So that's one concern about it. And again, just splitting hairs here, but technically if we file a claim on the bond today and the bond expires at the end of the day, that claim still applies. It was made during the life of the bond.
Right, that's my understanding.
So,
I was just curious if that kind of puts on hold the bond being canceled.
No, I would put it differently. The bond's canceled, but that claim was
Okay.
filed pursuant to the bond when it was in effect, so that claim still
So no claims
applies.
after that would be
Right.
bothered. Okay.
Okay.
I
I just want to add just one gloss on things. Because this is a broker, the broker has found a contract. If there are any customers, the broker would have passed the customer on to a supplier. And the supplier, if there is a contract, the supplier would still be subject to the commission's full authority, at least as long as they remain licensed.
Okay, yeah, I was just going to suggest maybe as part of the order we, consider acting on the bond, at least to the extent we have that ability today and not tomorrow. So, thanks.
Commissioner Barbe.
Yeah, a couple of things. So if, let's say, the bond does go out of effect today, as I expect it will, and a couple of weeks from now, a consumer comes to us as the Public Service Commission and says, I realize I was misbilled a year ago by this company, would we be able to pursue a remedy against the bond company because it was during the period of the bond? Because that's my understanding of how bonds work. I mean, aren't they still obligated?
I don't think so. I mean, I think they're only obligated while the bond is in effect, and you have to put the claim in before the bond expires. That's my understanding. Now, again, I can't claim to be an expert on that.
Okay.
On that point, Commissioner Barve, if I could just add, that's also another reason to not cancel their license, because even if you can't reach the bond, you could still call upon the supplier to answer for any complaints that it has with CAD and actually go through the process of holding the supplier accountable, and then assess a penalty that is outside of the bond, because the commission could still assess a penalty, if I'm not mistaken, that does not necessarily draw upon the bond alone.
Well, that leads into my next question for anybody who's willing to answer it, is if we were to refuse to cancel their license and they responded by not extending their bond, is that a violation of the public utility article?
I would believe so, because under PUA 7-507C4, it says the commission shall, by regulation or order, adopt any requirements, but I'm sorry, I meant to cite Comar 2051-0202C. It requires brokers of electricity supply and electricity supply services to submit a $10,000 bond. And so if they are still licensed, they would have to meet that obligation. And if they don't want to be holden to that obligation, then they need to file a request to relinquish their license. So that's my assessment.
Thank you. That's exactly what I wanted to know.
Commissioner Sushman.
So from staff's perspective, I'd like to get a sense, based on the conversation we've had today, is it your position that where a broker fails to maintain their bond, we should cancel the license, or should we wait until they come before us and request that the license be canceled? So I guess the question is this good policy for us to be canceling licenses? Because you've heard some concern up here that we don't want brokers or retail electric suppliers to just stop maintaining their licenses, their bonds, and then have their license canceled without appearing before us.
And Commissioner, I would say historically that is what we've done, viewing the cancellation of the license as sort of the ultimate penalty in that regard. But in the context of the the Commission's reconsideration of how we handle the license verification process and/or withdrawal process, that's certainly something we would look at considering
Okay.
changing.
And I guess the other question is, I mean, we certainly, if we direct that the license be maintained, I would imagine that we don't want this person engaging in brokering services anymore. Can we? Do we have? Is it your understanding we have authority to direct that the license be maintained, but we suspend the person's activities in Maryland? Can we do one and then the other, so the license is maintained, but we really don't want this guy to be doing brokering services in Maryland?
Yeah, yes, Commissioner. I do believe the Commission does have the authority to do that. It certainly can suspend licenses, which is not the same as revocation. Or it can limit the activities that a broker could do. Again, with respect to the reference to the billing, it's staff's understanding that normally, a customer is billed by their supplier, not by a broker. The supplier is the one that actually
Right,
pays.
but they maintain a bond because there's some recognition that they could be engaged in bad behavior, and we want to be able to reach them to the extent that there is bad behavior discovered.
That's correct, Commissioner.
So, okay, thank you.
Commissioner Wood? Okay. All right, okay.
Sorry, I don't want to badger at this point, but it just seems to me that we have this $100 fine that is related to a 2023 failure to submit a form. But the fact that we received notice of a cancellation of a bond from a company before they've even let us know that they are going out of business, that they want to leave, are you telling me there really is no penalty involved in that, or the failure to maintain good standing with the state's SSTAT? I guess that's my question. Do we really not have any other areas where their failures don't rise to the level of some kind of a penalty?
So, as Mr. Spivak pointed out, staff's historical understanding and commission's practice had been that the revocation of the license for failing to comply with all the requirements of the license was the ultimate penalty, because then the company could not operate in Maryland. And as was the case with this one and the case that all of these filings have gone, staff does what it can to get into contact with the principal, let it know that its bond has been put under notice by the surety that it's going to be canceled, and try to get the principal to take steps to renew it with the principal. But ultimately, or with the surety, but ultimately it has to be the supplier that actually takes the initiative and gets back into compliance with its bond. We can't force it. We just
Again, I'm just, I thought it was well stated. I think there seems to be a big loophole here for a company to have these violations, which are pretty, severe, and we have no, I guess, other recourse than to revoke a license. But in this case, we have a company that just wants to walk away anyway. So,
Yeah, Commissioner, I appreciate your point. I mean, there is a penalty because they didn't file the gross operating revenue report, but your point seems a lot more serious. We're not imposing a penalty on the fact that they're letting the bond terminate during the course of their authorization, and we're not imposing a penalty because they're no longer in good standing. Why don't we impose penalties on those two things? I think that's a fair point.
Okay.
I can't give any great rationale why failing to file a piece of paper with the gross revenue rises to the level of a penalty, but these two other things that frankly are more serious in terms of protecting customers do not lead. But you're right. I mean, the point's being made by staff, this is how we typically deal with it. But you make a point that maybe we should reconsider that.
Yeah, we might not take a look at it.
I would put an addition on that as well. I mean, staff is not basically inherently an enforcement organization. We don't have either the resources or the mechanisms generally to do that. With the bonds, we get a lot of bond cancellations. And, there's a staff person who follows that and generally tries to ensure that bonds that are being canceled are being replaced. And in the vast majority of cases, that is what happens. But, staff doesn't have the resources to, in the situation where a company has chosen not to renew its bond and is basically trying to go out of business here to bring an action against them to impose a civil penalty, whatever that might be.
Okay. Well, it just seems that we, and again, if that's the way it is right now, so be it. But it may be something we want to look at because, I mean, if the bond is there and the principal is ultimately, required to make good to the surety company, that is some leverage we potentially have, to make sure that they're, they're obeying all of our regulations. So we may want to look at that. It's good that we have at least the $100 citation for the failure to submit a document, but we have more severe violations here, and we don't appear to have any ability to, again, levy any type of fines against the one thing we do have, and that is the bond. So anyway, thank you, Mr. Chair.
So if we file claim against the bond, isn't that likely to get the company's attention? Because isn't the surety company then going to do their best efforts to get a hold of this guy?
I would think that would be what occurs. I don't claim much expertise in that area, but I think that's
because it seems to me that part of the problem has been, this guy, is for whatever reason, either intentionally or unintentionally, not communicating with us, and so as a method of trying to get his attention, maybe if we put the claim against the bond for the amount that we're owed, even if it is a small amount, you know, I'm sure the surety company's not going to be happy about having to spend some of their money to cover for this guy, and they may be able to get his attention, in which case, you know, we can follow up by saying, look, you need to actually go through the formal process of relinquishing your license. You know, you can't just walk away and quit answering our emails and disappear.
Yeah, certainly, if we put in a claim against the bond, if we want to then subsequently try contacting the man further, we can
All right.
certainly do that.
All right, so let me move that we have the power to suspend the license, right?
You do.
All right, so I guess I'm moving that we suspend the broker license for Charity Plus Power, Inc., and that we file a claim for the amount of money that is owed the commission for the failure to file the proper report with the surety company, Travelers Casualty and Surety Company. And then contact the charity company and demand that they file the proper application for ending their license here in Maryland. So, Commissioner,
I have a question about that motion,
okay,
if I may. Clarify for me what the meaning of the word suspend is versus revoke. Perhaps I missed that explanation when you made it.
I don't think we made a precise explanation
Okay.
of that. It's a little, it's not the easiest thing, but if you revoke the license, you're saying that they have no authority ever to
Okay.
operate in Maryland unless they come back in and get a new license. If you suspend the license, you're saying this company remains subject to commission jurisdiction. The license remains in effect, but you cannot act under the license.
Got it, okay.
that works.
All right, I understand. Thank you very much,
Okay.
Mr. Chairman.
So with that, Commissioner Linton,
Aye.
Commissioner Suchman,
Aye.
Commissioner Barbe,
Aye.
Commissioner Richard.
Aye.
I vote aye. And with that, we're adjourned for the admin meeting.
Commissioner.
Yeah, so we'll come back in 10 minutes for the, we're doing the rulemaking, right? Yeah, for the